Hello and welcome to the NOFA Estate Codes of Texas School. I am your host, Jonah Wilson, and today we will be discussing Chapter 205, which covers small estate affidavits. Now, just to kind of give you a briefing, we're going to talk about using the affidavit to transfer ownership when someone passes away. Also, using the affidavit to transfer funds from accounts. And the last short video is going to be about the homestead rule that's involved. So let's go ahead and get started. We're going to start with the first section. As you see on here is 205.001 and .002. And I've decided to review some cases to add some context to this information. So the first case I reviewed was about a gentleman named David who passed away without leaving a will. So he passed away intestate. His only children believed they could immediately collect the money from his bank account, but they learned that Texas law required more than simply just proving they were his heirs. They waited the required 30 days, confirmed there was no probate case open, completed a small affidavit, a state affidavit, listed every known asset and debt, and obtained signatures from the required witnesses before submitting it to the probate court. And of course, after the judge approved the affidavit, the family presented the certified copies to the bank, and they followed all the requirements according to the section that's on the screen, 205.001 and 002. The bank released the funds without requiring the appointment of a personal representative, of course, to save the family both time and expense, while ensuring the creditors, heirs, and financial institutions were protected by the statutory safeguards. So, to kind of summarize this before we move on, the family, you don't have to wait for a judge to appoint someone to handle an estate. If a person dies without a will, the heirs may be able to use a small estate affidavit instead. To do that, they must follow the 6 rules, which includes the 30-day waiting, make sure no probate case is opened, keep the estate within the legal value limit, which you see on the screen, filing the affidavit, and getting the judge approval and following the remaining legal steps. The affidavit must also tell the truth about who the heirs are, what property the person owns, and what debts they owe. It's pretty simple. Just follow the steps, and the law gives the heirs a faster path to the estate. Now, as we move on to the next section, it's going to cover 003 to 005. And of course, I reviewed another case on this. This is about a gentleman named Robert who passed away owning a modest estate. His children filed a small estate affidavit. After reviewing the affidavit, the probate judge approved it because it met the requirements. The family obtained certified copies from the county clerk, delivered them to Robert's bank and investment company so the accounts could be transferred according to law. A few months later, another institution questioned whether they had authority to receive the funds, but the affidavit was approved by the court. It was properly delivered and maintained as a county record, so the institution couldn't rely on it as processing the transfers. The statutory process protected both the institution and the rightful heirs by creating a documented chain of authority. And to kind of explain it further, the middle steps is basically what this is for the small affidavit process. Under section 003, the judge reviews the affidavit. He may approve it if it satisfies the requirements of chapter 205. And then, of course, section 004 requires the distributees to provide certified copies of the approved affidavit to anyone who owes money to the estate, possesses estate property, or serves as a registrar, fiduciary, or transfer agent. And then the last one is 005. It requires the approved affidavit to become an official local government record, creating a permanent public record that others may rely on with dealing with this estate. And that's pretty much it for that. And finally, we get to the end of the chapter, and this one is about the homestead. I told you at the beginning there was a homestead version, and I still need to look into it further. It bypasses the $75,000 cap according to the law written. But for this example, it was a lady named Mary. She passed away. She only had her home in her estate. It was her homestead, so the children believed they were the only heirs. They completed the small estate affidavit, recorded it in the county deed records, and then sold the property to a person, and they purchased in what we call good faith. The buyers reviewed the recorded documents, paid fair market value, and moved into the property. However, several months passed, and another individual produced evidence that he was Mary's biological son. However, he was not listed in the affidavit. Well, because the buyer had no actual or constructive notice that another heir existed, Texas law protected his investment under the ownership of the homestead. They omitted the heir's claim to try to take the house back. So now the heir had legal remedy not against the buyer. He has to go after the heirs who received proceeds from the sale, and because they failed to disclose his interest. This also illustrates the purpose of these statutes. They promote reliable land records and protect good faith purchasers while still preserving legal remedies for heirs who were improperly omitted from the affidavit. And to get away from the story and kind of get back into the actual statute, it explains how affidavits work after a person's death. The chalkboard shows that an affidavit may transfer title to a homestead when it is the descendant's only real property, but it must properly be recorded. And it also explains that good faith purchasers may rely on the affidavit, while undisclosed heirs may still have legal remedies against the heirs who receive the sale proceeds. The board also teaches that people who rely on affidavits receive legal protection, so those who sign it remain legally accountable for its accuracy. And Chapter 205 generally does not transfer title to real property except in the limited homestead situation specifically authorized by law. And that's it. So if you have any questions about this or need to speak to someone about this, or if you're going through this, give us a call at 866-800-6632. Once again, that's 866-800-NOFA, N-O-F-A, 6632. And we'll be more than happy to help you. Also, our website is dallascountyoverges.com or overages.us. Yes, that's actually correct. And also our email is info@overages.us if you just rather send an email. I hope this information helps. We will be moving further through the estate codes that might apply to estate in the heirs, people post-death scenarios. Once again, I'm Jonah Wilson, and I hope this helps someone. God bless.